We are going on the record. If you want to talk, please go outside.
Judge,
Hold on. So we're on the record. It cause number 253-4377, 2505-146. I think that's all we have here, right?
Yes.
Yes. Okay, so guys, for the record, please announce yourselves. State.
Anna Eady, E-A-D-Y, for Mr. Wiggins.
Nathaniel Munier spelled M-U-N-I-E-R, also for the defense.
So hold on, before you get into anything, state. You wanted to bring something to the court's attention.
Yes, Judge. So we had received a call that Mr. Wiggins was in violation of the protective order that was in this VPO, and that he was reaching out to the complainant witness in this case. We have checked the jail calls. Those jail calls show that since March 24th, which is, of course, after the October VPO, since just March 24th, we have 293 calls made to the complainant's phone number. Just yesterday, we had, I believe, 28 calls to that number as well.
So in one day, you're saying he made how many calls?
So yesterday, he attempted 28 calls to the complainant's phone.
So, Judge, I'm going to preface this conversation with, Miss Eady texted me about 10 minutes ago, so I came up on short notice on this. But my understanding is that there's no longer protective order in effect, because it's been long enough that the protective order...
There's an order for him not to have any contact with her.
Are those part of his bond conditions?
Yes.
My client's not on bond.
He is not supposed to have any contact with her whatsoever.
I understand, Judge, but the way that this court and other courts in the county have structured those conditions have been bond conditions, which my client is not on a bond. He is in custody. He has not broken.
I have ordered him, even though he's in custody, not to call her.
I understand, Judge. Assuming that he had violated some form of a court order that is not a bond condition, I believe the appropriate remedy would be contempt, and which would be a separate criminal proceeding. At the same time, for Ms. Eady talking to me today, it sounds like that the court was going to order ad-seg in the jail, so the formal...
The only way that we can revoke bone privileges on someone is ad-seg.
Yes, Judge. My issue with that is it's a hammer when a scalpel is needed. So while I understand that the district attorney's office has alleged that my client is called a victim in this case, there's no protective order in place. The bond conditions are not in effect because he's not on bond, thus no crime has taken place. And third to that, Judge, if he's to move to ad-seg, he would not be able to make any phone calls, not just to the victim, but anyone, including counsel, which while we are here on a misdemeanor, he is in custody on a felony and relatively serious felonies, and not being able...
Okay, I understand your plight.
Yes, Judge.
But there are other remedies for you to be able to communicate. Letters, in person. But the only way for me to be able to ensure that the complaining witness is not called is to put him in segregation. That's the only way.
Judge, the problem is nobody would be able to be called, including our office as well as his felony attorneys. Letters through the jail are notoriously slow. A letter to my mother, who lives in the same city, takes 4 days. And in the jail, you're taking over
and
a week.
I'm willing to put him on the docket one time a week so you guys can have contact.
Which the problem is, Judge, we would no longer be able to have any form of private contact, and that would only take care of the misdemeanor and not the felony. And not to be impolite, Judge, him having conversations with us are saying, hey, what's going on with the felony? And any jail visits that take place in ad-seg are actually recorded. They're notified by counsel going through the door that those calls are being recorded.
I don't have any other option to not prevent
Judge,
phone calls.
This would violate my client's 5th, 6th, 8th, and 14th, off the top of my head, constitutional rights. Right, self-incrimination, because every conversation is going to be monitored going in and out of the jail because they're going to be recorded via jail visits. He will no longer be able to have private visitation inside the courthouse.
You can pull them out. You can have private visitation in the rooms there.
It's not about me, Judge. It's about felony court is a serious issue. But that's the.
Why are you worried about felony court?
Because that's why he's in, Judge.
Then that's also in because of ours. Our bonds are at $60,000.
I understand, Judge, but the reason that this is taking as long as it is and it's been taken as serious as it is because he's in custody on a felony, and this court making him to where he cannot participate fully with counsel is,
There are other means for you guys to participate, but I've ordered you not to have contact with her. You've called her now over 300 times. I don't understand why you guys aren't filing additional charges anyways.
sorry, Judge, I missed the last statement. I'm
The
sorry.
only way that I can prevent him from making 300 phone calls is to put him in
So
another wing.
I was going to talk with the DA, and obviously, if my client's making these calls, and that's an if, he's dialing a single number, the jail's numbers can be easily blocked. I've done it on my cell phone numerous times when I've changed cell phones. Over the weekend, last weekend, I had 15 jail calls from one client. And as annoying as that is, it's very easy to block it on your cell phone. And I assume the victim could do the same. I have not heard anything from the state.
Tell the victim what to do, Nathan. I'm not gonna say, can you please block your number so we can't call you?
The least restrictive means, Judge, strict scrutiny dealing with constitutional rights.
No other way to prevent him from making phone calls. I have acquiesced to you guys before, and I've admonished him before. Please don't. We put you in seg last time. You were there a month. You came here begging and pleading, I'm not gonna do it, I'm not gonna do it. And now we have 300 phone calls. So I don't know what else to do, but now back in ad-seg.
I'm going to sprinkle the word allegedly to the phone calls because it's the kind of thing where records would exist that have not been provided to the defense by the state.
Do you have the records?
Well, I mean, I have them, I just have to get I have to do the forms or get them up with the forms, yeah.
Okay, so let's set up for a formal hearing because I don't want, you're right. I don't want to give you state the benefit of the doubt without him actually, or Anna actually seeing it and seeing that the phone calls were actually made. So let's set it for a formal hearing. How soon can you get him the evidence?
Trying to think about last time that I had to. It could be tomorrow, it'll be a few days. So, I don't know who wants that up next Monday or something like that. I think I should have it by then. This was just the one that I actually not to spend some places.
And if we could keep him in normal population so that we could visit him, as does his felony counsel, and they could
Wiggins, I'm going to have you sign an affidavit today promising me you're not going to reach out to the complaining witness in this case by any means. If you do, I can have a contempt hearing, and every single time it's punishable by up to 6 months in jail and a $500 fine per the advice of your lawyer. Because he thinks this is the correct avenue instead of ad-seg. Do you understand? Look, don't contact the complaining witness. Don't use anyone else to contact the complaining witness. Don't use anyone else's number to contact the complaining witness.
I'm going to rephrase what he just said. That means calls going through third parties. So if you call mom and have mom call her, that's against the rules. If you call mom and have mom forward the call, that's against the rules, et cetera, et cetera.
Yeah.
Okay.
This is the affidavit that you're going to sign promising me you're not going to contact her or the complaining witness in any of my misdemeanor cases. Do you understand? Okay, so you want to set it for Monday? Okay. But just get it as soon as you can, get it to them. Have a hearing on Monday to see whether he's actually making the phone calls that we ordered him not to.
This is you swearing that you will not make these calls.
And let it be clear that I truly have no least restrictive means than to deny his ability to make phone calls to the complaining witness. There really is no less restrictive means.
Judge, my understanding is that the jail can prevent Mr. Wiggins' SPIN number from calling him.
In the last time, he used someone else's SPIN number to make the phone calls.
That was last
So,
Yeah.
well, we'll see this time. I don't know. Okay, all right.
Just always tell the record, Mr. Wiggins, I want you to make this aware that this is the court having you swear, which is legally binding, that you will not be making any calls. And if you violate this sworn oath, then that is punishable under the law. You understand?
Sure.
Okay.
What makes this moment so compelling isn't just the number of alleged calls. It's the collision between judicial authority, constitutional rights, and real-world jail logistics happening in real time. On one side, the court is staring at what appears to be an ongoing pattern of behavior that directly threatens the integrity of a protective order and the safety of a complaining witness. Nearly 300 calls is not a misunderstanding, not a one-off lapse in judgment, and not something a court can simply ignore without risking serious consequences. From the judge's perspective, every unanswered call represents a failure of the system to protect someone who the court has already determined needs protection. And when that happens, the responsibility lands squarely on the bench. On the other side, the defense raises an argument that cuts straight to the heart of constitutional law. Administrative segregation is not a minor inconvenience. It is a severe restriction that affects communication, access to counsel, and the ability to participate in one's own defense. The defense isn't arguing that repeated contact is acceptable. Instead, they are arguing that the remedy must match the violation, and that the court cannot use a sledgehammer where a scalpel would suffice. Their concern is not hypothetical. Incarcerated defendants already face enormous barriers when working with counsel, and eliminating phone access entirely creates a ripple effect that touches felony cases, attorney-client privilege, and due process rights. This is where Judge Fleischer's courtroom style becomes especially clear. He does not rush to punish, but he also refuses to pretend that the problem doesn't exist. The judge repeatedly circles back to one central issue: control. The court must have a reliable way to stop the calls. Warnings have already failed. Admonishments have already failed. Prior segregation has already failed. When every lesser measure collapses, the judge is left with a narrow set of tools, none of them perfect. His frustration is not emotional. It is institutional. Courts are not designed to negotiate endlessly with repeat violations. At some point, compliance must be enforced. What elevates this hearing beyond a routine bond dispute is the judge's willingness to slow the process down rather than escalate it prematurely. Instead of immediately ordering segregation, Judge Fleischer demands proof. He acknowledges the word allegedly. He recognizes that records matter, and in doing so, he protects not just the defendant's rights, but the legitimacy of the court itself. A ruling without evidence would weaken the very authority he is trying to preserve. By setting a formal hearing and requiring documentation, the judge reasserts control while still honoring due process. The affidavit becomes the pivotal moment. This is no longer about jail policy or phone systems. It becomes a sworn promise directly to the court. That shift matters. A bond condition can be argued. A jail policy can be challenged. But a sworn oath creates personal accountability with clear consequences. The judge makes those consequences unmistakable. Contempt charges, additional jail time, fines, stacked one violation at a time. It is a warning wrapped in restraint. One last opportunity to comply before harsher measures become unavoidable. This hearing also exposes a reality most people never see: the tension between what the law allows and what jail systems can actually enforce. Blocking numbers sounds simple until multiple pins, third-party calls, and workarounds enter the picture. The judge is not naive about this. He references prior behavior, prior segregation, and prior failures. His skepticism is earned, yet he still chooses a path that preserves appellate integrity. If segregation comes later, the record will be clean, documented, and defensible. In the end, no one truly wins this moment. The defense succeeds in delaying segregation, but only under the weight of a sworn oath that carries serious risk. The prosecution secures judicial recognition that the calls are unacceptable and potentially dangerous, and the judge retains the ultimate authority to escalate if compliance fails. What the audience is left with is something far more powerful than a shouting match or a dramatic outburst: a live demonstration of how the justice system balances power, rights, and responsibility under pressure. And that balance, fragile, tense, and constantly tested, is what makes this courtroom moment impossible to look away from.